You won at court but still haven't been paid what's owed to you? What now? In this video, I'm going to walk you through how to obtain a writ of seizure and sale of property if a debtor refuses to pay the amount they owe you, despite being ordered to do so by the Ontario Small Claims Court. Hi everybody, my name is Weiting Bollu. I am the CEO of Openroom.ca. Today's video is made in partnership with CourtReady.ca, which builds practical tools and lessons for self-represented litigants across Canada. Let's start with, what is a writ? A writ lets the Small Claims Court's enforcement office to, through a sheriff, seize specific personal items that the debtor owns, sell them at a public auction, and then use the proceeds to help pay the judgment debt. Step 1. Decide whether a writ actually makes sense. Before you start, pause and ask one question. Does the debtor actually own valuable personal property that someone can seize and sell? This procedure can cost real money, so do some homework first. If you can confirm the debtor owns items with real value on it, you improve your odds. Step 2. Know what you can and cannot take. So a writ targets personal property. That means physical possessions, not wages or bank accounts. But the law also protects certain basic items. So for example, a debtor can keep certain categories of personal property up to specific limits, including clothing, basic household items, food and fuel, tools and instruments used for the debtor's business, and a car. In plain terms, you cannot use a writ to strip someone of basic necessities. You can and must aim for property that the law actually allows the bailiff to seize and sell. Step 3. Confirm you are within the time limits to issue the writ. Don't act too late. You must request it within 6 years after the court made the order. If more than 6 years have passed, you can still get a writ, but you must first get leave. In other words, permission from the court. Step 4. Prepare the affidavit that proves how much the debtor still owes. To start the writ process, you file an affidavit for enforcement request, which is the Form 20P. In that affidavit, you must state and describe the court order you are enforcing, including the court location, the amount still owing, the pre-judgment and post-judgment interest. But if you don't know how to calculate the interest, you can use CourtReady.ca's free judgment interest calculator. The key point is, you must clearly identify what the debtor still owes today, not what they owed on the date of the judgment. Step 5. Prepare the writ form. Next, you complete the writ of seizure and sale of personal property, Form 20C. The rules also require the writ to show your name, address, telephone number, and your representative's name, address, telephone number, if you have one. That detail matters because the bailiff must know where to send the notices and updates. Step 6. File the affidavit and writ with the Small Claims Court. You file both documents with the court where you obtained your judgment. You can also file online through the Small Claims Court Submissions online portal. Court staff will then issue the writ and return the issued writ to you so you can file it with the enforcement office. You will pay a fee to have the court issue the writ. Step 7. File the issued writ with the enforcement office or the bailiff. Once the court issues the writ, you must file it with the enforcement office, the bailiff responsible for enforcement. At this stage, you move from paperwork to action. The bailiff cannot enforce a writ that you never file. Step 8. Tell the bailiff exactly what you want seized and where to find it. You should give the enforcement office written instructions identifying what property you want seized and enough detail to allow enforcement staff to locate it. You can use a direction to enforce writ of seizure and sale of property form, which is the Form 20O for this particular step. But be specific. If you want the bailiff to seize a particular item, you need to provide details that make that actually possible. Step 9. Pay the enforcement fee and deposit. The enforcement office will require an enforcement fee and a deposit to cover expected enforcement expenses called disbursements. Now, these disbursements may include things like freight, insurance, locksmith services, storage, mileage, and advertising costs for the auction. If the bailiff spends your deposit before the process finishes, the office can then ask you to top up the deposit. This is one of the most important practical realities. You may need to spend money to try to recover money. Step 10. Understand when the bailiff may refuse to act. The enforcement office has a duty to act reasonably and in good faith towards both parties. That duty leads to a key point. The enforcement office can refuse to act if the expected costs of executing the writ are higher than the debtor's equity in the property. In other words, if the bailiff estimates that the seizure will cost more than it will produce, the bailiff may refuse to proceed. Step 11. Seizure and storage of the debtor's personal property. If the bailiff proceeds, enforcement staff will seize the items and store them until the bailiff holds a public auction. At this stage, the bailiff controls the seized property. Step 12. The debtor can request an inventory of what the bailiff had seized. If the debtor asks, the bailiff must deliver an inventory of the personal property seized within a reasonable time. This requirement protects transparency, naturally. It also helps prevent disputes about what the bailiff actually took. Step 13. The bailiff must give notice and advertise the sale before selling anything. The bailiff cannot sell seized property without giving advanced notice and advertising the actual sale. The rule requires the bailiff to mail notice of the time and place of sale at least 10 days before the sale to you at the address on the writ or to your representative, and to the debtor at the debtor's last known address. The bailiff must also advertise the sale in a way likely to bring it to the public's attention. Step 14. Public auction and payment of proceeds into court. The bailiff sells the goods at the public auction. After the sale, the proceeds go into court. The enforcement office then calculates the net proceeds, and then the court pays out to the creditor or creditors who initiated this enforcement. Net proceeds means that the system accounts for costs and fees before it actually distributes the money. Step 15. Special note if you target a vehicle, snowmobile, or a boat. If you ask to seize a motor vehicle, snowmobile, or boat, you must provide proof that you completed specific searches and ownership checks. The goal is to confirm liens and confirm that the debtor actually owns this vehicle. Practically, this step protects you from paying to seize something that has no equity left after secured claims. All right, time for our rental trio, your takeaways for this session. Writ of seizure and sale of personal property can help you enforce a small claims court judgment, but you need to plan carefully. And you do best when, number 1, confirm that the debtor actually owns valuable property that the law allows you to seize. Number 2, give the bailiff clear instructions and good information. And number 3, budget for enforcement deposits and expenses because it could add up. That's a wrap. If you enjoyed this and learned something new, make sure to subscribe for weekly lessons. You learn, I learn, we all learn. I will see you next week.